welcome to another episode of Cut to the Chase, where we chat up on laws beyond citations. This is the second episode to be precise, and we have a judgment in the public domain from the Madras High Court which says that fundamental rights and fundamental duties should be effectuated in a balanced way and in equal measure. Now, this conversation has been in the public domain for a very long time, and this issue of whether fundamental rights and fundamental duties hold equal importance has been an ongoing debate, but really nothing happens out of it and nothing really comes out of it. So to discuss this issue, this judgment and the entire issue behind it, we have with us today a lawyer who's been kind enough to join us, Mr. Sarthak Raizada. I'm going to give you a brief introduction about him. I'm going to read it out. I want to get it right. He's an independent counsel and he practices in Delhi, and he has previously worked as a research assistant to Dr. Anirudh Rajput, who is a member of the International Law Commission, and he has assisted him at the 71st session of the International Law Commission held in Geneva in Switzerland. Now, he's also worked as a junior counsel at the Additional Solicitor General's Chamber of Mr. Vikramjit Banerjee, and also been an associate with the antitrust team of Amarchand Mangaldas and Company. Hi, Sarthak. So we'll just cut straight to the chase. And I wanted to now come to you and ask you, what is this judgment really about? And what are its implications on the general public?
Okay, so very simple case. A government servant had solemnized a second marriage during the existence of the first. Subsequently, his first wife died. Then the government servant applied to the government authorities to nominate his wife for pensionary benefits, the second wife. And that application was rejected. In the interim, the husband also died. So the second wife applied to the accountant general saying that grant me these pensionary benefits of my husband. That application got rejected. She approached the High Court saying that I am entitled to these pensionary benefits. The High Court rejected her petition saying that this goes against the conduct rules, which places an embargo on a government servant to solemnize a second marriage during the existence of the first. And this was an admitted position. There was no dispute that whether the second marriage was solemnized during the first or not. And in this backdrop, the court, after rejecting a petition, seems to be lamenting about the fact that the government has not been enforcing fundamental duties properly. And what seems to weigh with the court here, Sanya, is I believe that in Tamil Nadu especially, there seems to be a widespread practice where people, especially government servants, are entering into second marriages during the existence of the first. And I say this because there are a bunch of litigations in the Madras High Court regarding this. And this issue also came up in 2020 before the Madras High Court. And this very issue was referred, interestingly, to a larger bench by a single judge. There is a 19th March 2020 order by a single judge of the same High Court saying that whether a second wife is entitled to pensionary benefits is something that should be referred to a larger bench because there are conflicting decisions in the same High Court. But nonetheless, this learned single judge still decided the matter because there's a division bench judgment of the same High Court which holds the field saying that the second wife is not entitled to pensionary benefits if the marriage has been solemnized during the existence of the first. But be that as it may, this is a limited question that was before the court. But the court went ahead and made these general observations. And these are the reasons which I just told you that seems to weigh with the court for making these observations, that the government is not doing enough to enforce the fundamental duties. And one of them is to renounce practices which are derogatory to the dignity of a woman. This is specifically stated in Article 51A. And again, at the end of the day, it remains the government's responsibility to enforce these duties because the court cannot issue directions for enforcement of these duties per se.
So I'm trying to understand this. The issue was that whether the second wife is entitled to the benefits.
Right.
And the court went on to say that no, she's not entitled to the benefits because of her husband who entered into a second marriage with her.
Right.
And because he did not subscribe to his duties.
Right.
Under the conduct rules, this lady will not be entitled to the benefits, first.
Right.
And second, I'm trying to understand it from the perspective of the larger question which he has gone on to comment on.
Right.
which is the fundamental and rights and fundamental duties issue.
So yeah, those are observations of a purely general nature. And the court seems to think that the government should do more to enforce these duties, especially when it involves government servants who should lead by example in these matters. Because bigamy is, according to one view, understood to offend the dignity of the first wife. And therefore, the court thinks that there is a legitimate state interest involved in curbing these kind of practices, especially when you have the Hindu Marriage Act, which says that if there's a living spouse and the person gets married again, then that marriage is void. Of course, there is an issue regarding whether these laws are discriminatory because it applies to one religion, not the other. But that's a separate issue. Here, the court was merely concerned with enforcement of the fundamental duties and the rights of the citizens. The court said that there has to be some balance that has to be struck by the government itself. Mm-hmm. So these are the backdrop of and what weighed with the court in making these observations.
And we were actually talking about this amongst ourselves, and we realized that the Madras High Court has often passed judgments like this, where they go beyond what they're supposed to adjudicate. And right. They often comment on things that are, I won't say not relevant, but perhaps not on the table right. at that point right. in time. So do you think this is a trend which has recently begun? I mean, I like to call it rhetoric, right. but I don't know what others do. So do you think this is something which is happening, and right. is it cool?
So no, I don't think it is about being cool. See, there are two kinds of disputes, Sanya. One is a purely private dispute between the parties, which has no general implications for the public at large. Mm. And then there is a second kind of dispute, which may have some sort of a public interest involved, where there is a state interest involved. So when there is the dispute of the first kind, which is the purely private dispute, and still the judge goes ahead and decides something which is not before the judge, he's not, then he's traveling beyond the list that is before him, the dispute that is before him. And in those cases, I would say if observations are made by the court, that those are generally of an extremely unwarranted nature. But when you're talking about constitutional adjudication, I believe courts also play a role in educating the public, in reminding about their civic duties. And in today's age, when we see that civic duties have fallen to the side, and people generally don't follow them. They are more fixated about their own rights, enforcement of their own rights, and not being concerned about their duties. So this is where I think courts should step in and remind the government and the citizens about enforcing these duties and observing their own duties. Because to me, rights and duties share a dual relationship. And if I have to break it down in the most rudimentary terms, it means that my freedom to do with my fist as I please ends where my job begins, right? Where somebody else's job begins. So I can't be seen as impinging, trampling upon somebody else's rights, and while saying that I want to enforce my own right, because there is the corresponding duty every person has.
So let's try to juxtapose this on the basis of what has recently happened in Karnataka. We have protesters in the hijab controversy saying that it is our right, it is our fundamental right to wear the hijab. And therefore, we want to protest if right. the state is not allowing us to do it. Right. Now, at the same time, we have a person called Harsha who gets murdered amid all this. Right. Yeah. Do you think there's a clash going on here between the rights of one group and the rights of another group? And is it a balance that needs to be, is there a balance that needs to be created? Also, when we're looking at, this entire picture, how do we really enforce this balance that you just talked about? Because there is a possibility of state excesses, all of that. I mean, I hear it all the time. Let's just balance it out. Let's just do this. But how do we do it? How do we, what's the solution?
So 2 points there, Sanya. The first, to respond to the first question that you just raised, I don't think there can be any balance between rights and violence. Violence has to be prohibited. There has to be law and order, which has to be enforced by the states. But at the end of the day, it's also the duties of the citizens to abjure from violence. So when this innocent man, Harsha, was attacked and he was killed, I must say it was a cold-blooded murder. And according to reports which have emerged, this was a well-conceived plan to murder him. There was a vehicle that was brought on hire from outside the state. They went to a blacksmith to purchase a weapon. And then this person was murdered. This was outrightly a religious murder, I will say. This was influenced by religious feelings, where members of one community cannot understand that this person was only asking for uniformity in a place which is already secular. Uniformity in the dress code. A secular place should have secular practices. And when people say that wearing hijab is not just a religious practice, it's also a part of their Article 19, I must remind them one thing very, very clearly, that wearing hijab predominantly remains a religious activity. It has religious undertones. According to the members of that particular community, it is an injunction of their religious texts. So if I proceed on the basis of their own perception, it predominantly remains a religious activity. It predominantly remains a religious attire. And therefore, to say, I will insert that very right from the back door of Article 19, it's completely misconceived. And second aspect, Constitution gives you the right to attack ideas. It does not give anybody the right to attack people. So whenever you disagree with somebody, it does not mean you go ahead and kill that person. And then you say, this is my right to protest. So these things, I believe they cannot be balanced. There cannot be any balance between violence and the enforcement of rights. Violence has to be prohibited at the outset. Now, so far as the balance between fundamental rights and fundamental duties are concerned, this issue is no longer that must be debated. We have not one, but in many judgments, the Supreme Court has said that rights have to be balanced against the duties.
Right, I think this was a Shaheen Bagh issue. I mean, if I'm not wrong.
Yes. So there the court was balancing the right of protest against the right of movement. The right of protest is available under Article 19. Right of free movement is available under Article 19. So whenever you say that I have a right to protest anywhere I want to, then that's subject, that you have certain duties to other people. You owe those duties to other people. And when you talk about that duty, there is a corresponding right that is available to the other person. So to say my rights are absolute and not subject to, and how this balancing will take place, Supreme Court Ram Leela Maidan case said the same thing, that these rights come with duties. And today, to say that there has to be some balance, we have truckloads of jurisprudence on this.
No, there may be jurisprudence, but the other side of the spectrum says that, there can be state excesses when you enforce these duties at par with rights. So that seems to be the issue, I think.
Yeah, so that issue, I must say, so when Sanya, fundamental duties were inserted in the Constitution, they were introduced in 1976. So when H.R. Gokhale was introducing these duties, he made these very important observations, and I must read them out. And then I will come later to what Dr. Ambedkar said in the context of minority rights. So first, Mr. H.R. Gokhale, who was the law minister back then, when introducing this chapter, he said, we have a very new thing, the enumeration of duties, for which we are proposing to add a chapter, which is not there now. It has always been regarded by all right-thinking people that if you're conscious of your rights, it is no less important that you must be equally conscious of your duties. For the first time in the constitution of a country, we are proposing to incorporate that. So this was the backdrop. So, and another backdrop was that when we were fighting against colonial rule, we stressed a lot on our rights. And when our constitution came into force, there were no fundamental duties in place. And for almost 20 years, we forgot about those duties. So therefore, the constitutional framers thought it fit that people should be reminded about the duties that they have, not just towards the state, but towards each other as well. So this was the broad backdrop in which, and need I also say that even before the fundamental duties chapter was inserted, was made part of a constitutional scheme, we already had the 1971 Act, Prevention of Insults to National Honors Act. So parliamentary intention had already been expressed, where you can't insult national symbols, national anthem, the national flag. So these were subsequently made part of the constitutional scheme, but you already had a parliamentary intention which was expressed in the form of a legislation. So for long we have fundamental duties which have been part of our constitutional scheme, but I will say they were only made explicit by Article 51A. Look at the preamble. It also talks about fraternity. So fraternity is about respecting the other people's ideas. Tolerance is about respecting the other people's ideas. You can't go ahead and kill people for their ideas, because if that happens, you are living in a mobocracy.
Correct. Right. So, I mean, this is an issue which has a lot of dimensions. So if we look at it only from one perspective, we'll have to jump to the other also and put some light on it. Right. So keeping that in mind, I wanted to wrap this up here and leave everybody with more food for thought. And, we'll be able to take this forward, maybe with some new issue which comes up and crops up, and hope to have you again. This was very insightful. Thank you very much.
This was very engaging for me as well, Sanya. Thanks for having me.
Thank you. Take care. Bye-bye, everybody.